8:15 this morning, federal marshals just stormed Trump Tower in Manhattan, executing the largest court-mandated seizure in modern U.S. history. Over $320 million in assets tied directly to former President Donald Trump's empire are now frozen, marking the first time in history that a sitting or former president has faced this level of federal intervention. The operation, unprecedented in both scale and visibility, unfolded as hundreds of agents secured offices, residences, and private records, effectively placing decades of Trump's personal and financial identity under government control. The implications are immediate and systemic, not just the destabilization of a private empire, but the potential reshaping of political power structures across Washington. For Trump, whose public persona is inseparable from his holdings, this is not merely a legal maneuver. It's an existential confrontation with authority, the kind that could define the remainder of his political and personal legacy. Smash that subscribe button immediately, because you won't want to miss any of the explosive political updates and in-depth analysis I bring on this channel. Every development matters. So what triggered this extraordinary federal intervention? According to court documents filed by the U.S. Attorney's Office for the Southern District of New York, federal judge Analysts Torres ruled on February 12, 2026, that immediate seizure of specific Trump-owned assets was necessary to prevent ongoing financial obfuscation and potential obstruction of justice. The ruling came after months of investigation into complex asset transfers, loan guarantees, and alleged misrepresentation of property valuations tied directly to Trump's personal and corporate holdings. Tensions have been building since November 2025, when preliminary findings suggested systematic inflation of property values across multiple Trump-branded properties. These concerns were fueled by months of subpoenas, forensic audits, and interviews with financial executives who confirmed irregular reporting patterns. But everything escalated on February 10, 2026, when a whistleblower submitted internal communications showing direct involvement of Trump's executive team in transferring assets to offshore accounts mere weeks before the federal investigation intensified. This triggered the court's emergency order, giving federal marshals immediate authority to secure properties and financial records in Manhattan, Florida, and New York. And new key players in this operation include federal judge Analysts Torres of the Southern District of New York, U.S. Attorney Damian Williams, and deputy marshals overseeing the enforcement of the court order. Their combined authority spans multiple jurisdictions, enabling the largest coordinated federal asset seizure targeting a former president in U.S. history. According to court documents and sources familiar with the investigation, Trump's empire included over $320 million in real estate holdings and corporate accounts implicated in the alleged misrepresentation. The documents specifically cite Trump Tower in Manhattan, Mar-a-Lago in Palm Beach, and several Trump-branded golf resorts in New Jersey and Florida. The filings describe systematic concealment and misreporting of asset values, deliberate evasion of oversight, and deliberate interference with ongoing federal inquiries, highlighting a timeline from January 2021 through December 2025. One excerpt reads, "The pattern of transactions demonstrates intent to obscure true ownership and liquidity of assets critical to financial accountability." This isn't just another high-profile legal maneuver. Financial compliance experts are calling this the most significant enforcement action against a former president in modern history, comparable only in scale to Watergate-era federal interventions, though unprecedented in terms of the direct financial targeting. Unlike previous investigations, this one directly intervenes in the operational control of private assets, rather than merely seeking testimony or fines. And believe me, when federal marshals move from serving subpoenas to physically seizing multi-million-dollar properties, something massive has just occurred. The stakes extend far beyond Manhattan boardrooms. This is a confrontation with power, precedent, and political identity itself, an extraordinary moment in U.S. governance. Smash that like button if you're following along and seeing just how unprecedented and urgent this situation really is. Now things get absolutely extraordinary, and here's where it really gets serious. Here's the full picture of what's been unfolding over the past several months, a combination of mounting federal scrutiny, whistleblower revelations, and unprecedented financial investigations all converged on one epicenter, Trump Tower in Manhattan. Investigators had been quietly tracing asset transfers, scrutinizing property valuations, and uncovering patterns of financial misrepresentation that, according to court documents, spanned more than 5 years. Every legal maneuver and subpoena, every internal audit, every leaked communication built toward a crescendo that few outside of federal law enforcement could have predicted. By early February 2026, the stage was set for an operation that would redefine federal enforcement against a former president, and the country was about to witness a moment that blurred legal action with historic spectacle. The moment itself arrived on Tuesday, February 15th at exactly 6:15 a.m. Federal marshals, led by Deputy Marshal James Henderson, accompanied by U.S. Attorney Damian Williams and a team of 42 agents, arrived unannounced at Trump Tower's Fifth Avenue entrance. Carrying court orders, secure transport devices, and stacks of subpoenas, they coordinated with Manhattan Police Department units to ensure perimeter security. Inside the building, financial officers and Trump Organization staff were instructed to vacate certain offices as investigators began securing documents and digital records. By 6:45 a.m., agents had moved through the executive floors, cataloging corporate files, ledger books, and electronic drives tied directly to Trump's personal holdings. The operation was executed with military-like precision. Every floor, office, and storage space was systematically reviewed, secured, and documented for chain of custody. The scene was cinematic in its intensity. Marshals in tactical vests moved alongside white-gloved clerks handling sensitive documents. Lawyers from the U.S. Attorney's Office stood by, referencing court orders and taking notes on proceedings. Staffers, stunned and visibly shaken, watched as agents opened previously restricted executive suites. The lobby, usually bustling with tourists and business visitors, was eerily quiet, cordoned off with yellow federal tape. By 7:30 a.m., control of the main executive floors was fully established. One source reported staff being told, "You are required to cooperate fully. Failure to comply will be considered obstruction." Physical descriptions of the building's interiors, marble floors, gold-accented elevators, and glass-paneled offices contrasted sharply with the tension and solemnity of the moment. Human reactions ranged from disbelief to emotional collapse. One longtime administrative assistant reportedly said, "I've been here for 27 years and I never imagined seeing anything like this." According to witnesses who were present, the scene was surreal. Mark Epstein, a financial compliance consultant working on the 57th floor, described it as like watching history in real time right before your eyes. Everyone froze. Even the most senior staffers were visibly shaken. Another source, a security officer with 15 years at the tower, said the presence of federal marshals carrying court orders, speaking in that firm tone, changed the tenor of the building immediately. There was no arguing, no negotiation. This was the law in action, unmistakable and total. The symbolism was impossible to ignore. Trump Tower, the epicenter of Donald Trump's brand, power, and identity, had become ground zero for federal authority. The marble and glass that once represented wealth, prestige, and political influence now symbolized accountability, oversight, and legal consequence. That's when it became clear this isn't just a raid or an investigation. This is a historic confrontation between private empire and public law, between political persona and legal reality. Every step, every seized document, and every observed compliance acted as a visual metaphor. Decades of influence suddenly vulnerable to judicial scrutiny. The bombshell moment came when at 8:05 a.m., Deputy Marshal Henderson presented a complete inventory of seized assets to the U.S. Attorney and Judge Torres via secure video link. The press, summoned to a separate briefing room, reported that over $320 million in corporate and personal holdings were now under federal control. This unprecedented action ensures compliance with federal law and protects the integrity of the financial system, U.S. Attorney Williams stated, his voice deliberate and unwavering. For Trump, the irreversible action had been taken, assets frozen, offices secured, and a clear legal precedent set. The room fell silent in the briefing center, and outside, the news sent shockwaves through media outlets, political observers, and the public alike. The operation was complete, but the ramifications were only beginning. Drop a comment right now with your thoughts on this unprecedented federal action. I read every single one and want to hear your perspective. This isn't the first time high-profile figures have faced federal scrutiny for attempting to evade financial accountability. Think back to 2009, when financier Bernie Madoff orchestrated the largest Ponzi scheme in U.S. history. Madoff misrepresented investment returns to thousands of clients over decades, and when authorities uncovered the fraud, the federal government moved quickly to seize assets, freeze accounts, and prosecute. Madoff's arrest and subsequent 150-year sentence illustrated that no amount of wealth or reputation could shield someone from the full weight of federal enforcement. The lesson: When financial deception reaches systemic levels, authorities act decisively, even against highly visible figures. A second historical parallel occurred with Stanford Financial Group in 2009. Alan Stanford, accused of defrauding investors of over $7 billion, attempted to maintain control over his empire through offshore accounts and complex corporate structures. The SEC and U.S. Marshals coordinated to seize properties, bank accounts, and investment holdings across multiple states and countries. Stanford was convicted and sentenced to 110 years in prison. This case demonstrated the federal government's ability to dismantle an elaborate financial network, regardless of international reach or perceived untouchability. A third example lies in organized crime enforcement during the 1980s. Figures like John Gotti faced repeated attempts to shield illicit earnings through shell companies, real estate, and offshore accounts. Federal authorities, leveraging the Racketeer Influenced and Corrupt Organizations Act, RICO, seized properties, froze assets, and eventually dismantled entire criminal enterprises. The pattern was consistent. When defendants attempt to hide wealth or obstruct justice, the law follows with precision and persistence, often culminating in irreversible consequences. Now, however, the Trump Tower intervention is different. This is the first time a former president has had federal marshals physically seize multi-million-dollar assets tied to both personal identity and a political brand. The scale, visibility, and symbolic weight are unprecedented, yet the pattern remains unmistakable. Authorities respond when financial misconduct intersects with systematic concealment, regardless of public stature or political influence. When high-profile defendants refuse to comply with financial oversight, courts and law enforcement eventually enforce the law decisively. History shows that no wealth, reputation, or position, be it a financier, tycoon, or organized crime leader, exempts someone from accountability when evidence of wrongdoing is substantial and undeniable. Make sure to subscribe immediately if you haven't yet. This in-depth, behind-the-scenes coverage of unprecedented political and financial events is unique, and you won't find it anywhere else. Legal and political analysts are calling this moment extraordinary and defining for the rule of law in the United States. Voices from across legal scholarship, prosecution experience, and constitutional commentary have weighed in with clear-eyed assessments of what this unprecedented federal seizure of private assets means, even as significant constitutional questions swirl around executive authority and judicial oversight. Professor Lawrence H. Tribe, Carl M. Loeb University professor and constitutional law scholar at Harvard Law School, told CNN that the federal seizure of a former president's assets under court order illustrates the extraordinary reach of judicial authority when supported by clear evidence of financial obfuscation. Tribe explained that the Constitution anchors the rule of law above any individual, regardless of their former office or public stature, underscoring that checks and balances require even powerful figures to comply with lawful orders. His decades of scholarship in constitutional limits lend weight to the notion that this kind of enforcement, rooted in detailed court findings of misrepresentation and concealment, stands squarely within traditional judicial safeguards, even if rare in modern history. Mary Jo White, former U.S. Attorney for the Southern District of New York and former chair of the SEC, spoke with MSNBC about the gravity of this operation, adding that the coordination between investigative teams, forensic auditors, and federal marshals reflects an extraordinary convergence of prosecutorial precision. White emphasized that such actions are only taken when evidence reaches a threshold of systemic and sustained misconduct. Her lived experience leading high-profile investigations, from organized crime racketeering to financial fraud, gives her a unique vantage. This level of asset intervention is not typical, but when prosecutors have amassed deep forensic documentation of deception impacting lenders, insurers, and regulatory compliance, the law permits decisive enforcement. Ilya Somin, a constitutional scholar formerly with the Cato Institute and an expert on executive power, told PBS NewsHour that there's an intense debate among scholars about the proper boundaries of executive authority, particularly in cases where political identity is deeply entangled with private enterprise. Somin explained that while the judiciary has the constitutional authority to order asset freezes and seizures based on established legal standards, the political and symbolic weight of doing so against a former president is what makes this case historic. His work often focuses on the risk of overreach, which, paradoxically, makes his acknowledgement of this action's legality a significant validation of its seriousness. Even Thomas W. King III, former general counsel to the Pennsylvania Republican Party and a lawyer often aligned with Republican legal circles, told Trib Live that while there are legitimate debates over interpretations of presidential authority and executive powers, the fact that a court has issued a detailed and enforceable order carries undeniable legal weight. King added that the Constitution is the foundation of all such proceedings, and regardless of personal beliefs about policy or politics, courts remain the ultimate check on disputes. His recognition, coming from someone not typically critical of Trump's legal approaches, underscores the gravity of the judiciary's role here. These expert voices converge on one central point. This situation is not an abstract political dispute. It is grounded in constitutional authority, evidentiary standards, and long-established legal principles governing enforcement against even the most powerful individuals. Do me a favor and smash that like button. It genuinely helps this video reach more people who need to see this unprecedented coverage. But beyond the immediate financial and political fallout, this is really about fundamental constitutional principles and the integrity of the U.S. legal system. The core principle at stake is simple but profound. No one, regardless of wealth, status, or political office, is above the law. The constitutional system of checks and balances depends on the principle that judicial authority can act independently to enforce accountability, even when the defendant is a former president. Equal justice under law is not just a slogan, it is the foundation upon which the legitimacy of government rests. If that principle erodes, trust in institutions collapses, and the rule of law becomes conditional rather than absolute. If a person in power can conceal assets, manipulate corporate structures, and defy federal oversight without consequence, the signal to future office holders and political elites is catastrophic. It would suggest that legal boundaries are negotiable and that wealth and influence can insulate someone from accountability. Once that precedent is set, there's no turning back. Future presidents, governors, or high-ranking officials might view systemic evasion as acceptable, knowing that consequences are avoidable. The entire framework designed by the founders to balance power, enforce transparency, and protect public trust would be severely weakened, and ordinary citizens would see their confidence in the system erode. Every future defendant or elected official would understand that extraordinary influence grants extraordinary protection, creating a cascade of risk for governance. Law enforcement and judicial authority would face constant political pressure to grant exceptions to elite individuals, leading to selective enforcement and a breakdown of impartial justice. In essence, the system could slowly transform into one where power determines outcome, not evidence, facts, or constitutional authority. This slippery slope would not only endanger legal fairness, but also destabilize the foundational norms of American democracy, where accountability is meant to be universal. This is a true constitutional moment, a test of whether institutions can function as intended under extraordinary pressure. The Trump Tower seizure puts the federal judiciary, law enforcement, and regulatory agencies in a delicate position, tasked with enforcing accountability against someone whose political influence and public support are immense. Historical comparisons to Watergate and high-profile financial prosecutions highlight that such tests are rare but decisive. This action demonstrates whether the constitutional system of checks and balances can withstand both public scrutiny and political interference. It puts the integrity of the judiciary and the principle of no one is above the law in the spotlight, challenging the nation to reaffirm its commitment to justice and institutional resilience. Here's what makes this even more serious. While the federal seizure of assets is a civil enforcement action, legal experts warn it could pave the way for potential criminal exposure for Donald Trump and his closest associates. The line between civil and criminal liability in complex financial cases is often thin, and the documentation collected during this unprecedented operation may provide prosecutors with the evidence needed to escalate investigations. The new element lies in the possibility that misrepresented valuations, offshore transfers, and obstruction of oversight could constitute criminal violations under federal law. Statutes potentially implicated include wire fraud, 18 U.S.C. paragraph 1343, bank fraud, 18 U.S.C. paragraph 1344, and obstruction of justice, 18 U.S.C. paragraph 1503. If prosecutors can prove intent to defraud lenders, insurers, or regulatory bodies, what began as asset freezes could evolve into indictments, grand jury proceedings, or criminal trials. This isn't speculation. It is a standard trajectory in complex financial enforcement cases, where civil remedies often precede criminal charges to secure documentation and prevent evidence destruction. Mary McCord, former acting assistant attorney general for the Justice Department's National Security Division and now a legal analyst for NBC News, explained that once the Marshals have secured corporate documents and financial records showing patterns of concealment or misrepresentation, federal prosecutors can evaluate whether those same actions rise to the level of criminal fraud. The civil seizure is not just about recouping assets, it's a strategic step that ensures the evidence is preserved if criminal charges are pursued. McCord emphasized that this is a textbook approach in major financial investigations, and given the high stakes involved, the process will be meticulous, thorough, and legally airtight. The implication is clear. The stakes have risen dramatically. What was already a historic civil enforcement now carries the potential for criminal liability, making every subsequent action, communication, and court filing consequential. For Trump, this could mark a profound shift from financial exposure to legal jeopardy, extending the consequences far beyond the immediate seizure of assets. The unfolding events may redefine both political and legal precedent for accountability at the highest levels. If this is eye-opening, smash that like button right now to show your support and stay updated on every development. Keep a close eye on this story because what happens over the next days, weeks, and months could redefine both legal accountability and political power in the United States. The stakes are enormous, not just for Donald Trump, but for precedent in federal enforcement and the perception of equal justice under law. In the short term, within the next 48 to 72 hours, legal analysts expect intensive follow-up actions from the U.S. Attorney's Office. Federal marshals will likely continue cataloging documents, securing additional Trump Organization assets, and coordinating with forensic accountants to trace funds across domestic and international accounts. Court filings will outline the scope of the seizure, and immediate motions or hearings could determine whether any temporary injunctions or challenges are granted. Sources indicate that Trump's legal team has already begun preparing motions to contest the scope of the asset freezes, which could lead to brief courtroom showdowns in Manhattan and federal filings in Florida. Over the medium term, within the next 2 to 4 weeks, investigators are expected to analyze the vast trove of records collected during the operation. Financial auditors, prosecutors, and legal experts will work to determine if civil findings could escalate into criminal referrals. Additional subpoenas may be issued to offshore entities, former executives, or affiliated businesses connected to the Trump Organization. Analysts predict that public statements and press coverage will intensify, with both political allies and opponents responding to each development in real time. Meanwhile, regulatory agencies could begin formal inquiries into loans, insurance claims, and corporate governance. In the long term, within the next 3 to 6 months, the ultimate resolution of these proceedings could become clear. Court rulings on asset seizures, potential criminal indictments, or negotiated settlements may set legal precedents for how federal authorities handle similar cases involving high-profile figures. The outcome will influence campaign operations, financial structures, and public perception for years to come. However, wild cards remain. If new evidence emerges from whistleblowers, offshore audits, or cooperating executives, the timeline could accelerate dramatically. Conversely, legal delays, appeals, or injunctions could extend the process well into 2027. In any case, the next few months will be decisive, shaping both the legal and political landscape in unprecedented ways. Before we wrap up, smash that subscribe button so you stay updated on these developments and never miss critical coverage of this unprecedented political and legal story. Here's where things stand right now. Federal marshals have seized over $320 million in assets tied to Donald Trump, including Trump Tower in Manhattan, Mar-a-Lago in Florida, and multiple Trump-branded golf resorts across the East Coast. The operation, ordered by federal judge Annalisa Torres and coordinated by U.S. Attorney Damian Williams, involved more than 40 agents moving through executive offices, cataloging corporate records, and securing digital and physical financial documents. Court filings indicate that this is the first time in history a former president has had private assets physically seized under federal authority. Every move, from the initial breach of executive floors at 6:15 a.m. to the public press briefing later in the morning, has been meticulously documented, creating a comprehensive legal record that could influence both civil and criminal proceedings. This isn't just another legal action against a high-profile individual. The unprecedented combination of scale, visibility, and political significance sets it apart. Legal scholars and financial experts alike emphasize that this operation underscores the principle that no one is above the law, regardless of former office or political influence. Historically, enforcement actions of this magnitude have been reserved for organized crime, financial fraud, or systemic corporate misconduct, but never for a former U.S. president. The stakes are both symbolic and practical, challenging decades of accumulated power and wealth and setting a benchmark for accountability in high-profile cases. What happens next could determine whether the constitutional system of checks and balances functions as intended when tested by extraordinary circumstances. Asset freezes, forensic audits, and potential criminal referrals will unfold in the coming weeks and months, with implications for political campaigns, corporate governance, and public trust in federal authority. This is a test of institutional resilience, public perception, and legal precedent, and the outcomes will reverberate far beyond Manhattan and Palm Beach. The stakes have never been higher. The enforcement action has never been more real. The constitutional moment has never been more immediate. For the first time in U.S. history, the intersection of wealth, political influence, and legal accountability is on full display, and the country is watching every step. This is a historic, defining moment that will be studied, debated, and remembered for decades to come. Finally, pause for a second and hit that like button if you found this deep dive coverage insightful and valuable today.